From the daily list, item number 1.
May it please, Lordship. Lordship, as per the last order, Justice Kataki has submitted a report, my lord, and in response to that, we have filed the status report. Well, and if your Lordship will, the Justice Kataki has submitted 22nd report, my lord, regarding transportation of coal.
Yes.
And we have filed a status report on 3rd June 2024, my lord, pointing out that entire coal has been transported to coal depot.
Entry transport
To the coal depot, because from pit head it has been transported to coal depot, my lord.
Can you file a photograph?
Yes, my lord.
Yes.
I have.
He has gone there 2 months back. Police there.
So that's the 23rd. You give a status report, 23rd interim report, correct? Not 22nd.
We have received 22nd report.
23rd report was already since 1st of June.
We have not been furnished. 20 because the last time when matter came, my lord, it came on 3rd June, my lord. Sorry,
Before that,
on 3rd June.
23rd report was not finished.
No, we have not, because it has to be furnished by the order of judicial order only.
23rd.
Yeah. Yes.
24th. Yeah.
So, what's the reports today? Five status.
Yes.
No, only 23rd, not 24th.
24th.
24th is the observation.
Justice Kadaki has furnished. We'll see that furnished 24th copy maybe.
2 days. And then file a photograph. 23rd report and photographs.
We'll give them the amount of paying for us.
Yes, that giving 23rd report and file photographs.
You got 23rd report.
I have got 22nd report, interim report, which was, in response to that, we have filed a status report on 3rd June, my lord. And 3rd June
There are 2 reports. One is 23rd report and 24th report.
that we have
We'll
not.
hand over 23rd report now
Yes, my lord.
to take a photograph of the present situation.
Yes, my lord. There are two types of, so far
It appears that it's a different version is coming.
yes, I will just explain what has happened, my lord. There are two types of coal in Meghalaya. One under.
Now you take it. Now
Yes,
you
my lord, I will take it.
Yeah, we're not going to pass any orders.
Yeah,
We'll say we'll hand over a copy, then we'll see.
Yes, my lord. Only thing, just one line, my lord. There are coal which are seized under section 21. For that, those coals are not to be transported to coal depot of Coal India, because those coal will be auctioned by the concerned judicial magistrate in accordance with law. That is what all the Masa
Fine there.
all the Masa, all
They'll
judgment.
file a report. After taking this, they'll file a report.
I'll do that. So
Justice Kadaki has filed 23rd and 24th interim report. DGC is directed to forward hand over a copy of the 23rd report alone to the Advocate General. it has been brought to our attention that some coals are lying there and it has not been taken to the depot. Mr. Amit, Advocate General would submit that there are certain coal may be lying, but it has got to be disposed of by the concerned judicial magistrate.
And they have been seized under section 21 of MMDR.
Seized under section 21 of so-and-so Act. In order to enable them to file comments on the 23rd interim report and also the photograph of the place, call the matter after 3 weeks.
Item number 2.
Let all these matters be caught.
3 weeks, sir. Which one?
All three.
2 cases.
No, all matters.
Yes, 21.
May it please your lordship.
Same issue, my lord. Call. Let these matters be called.
Same date. So-and-so. Yes,
Both item 2 and 3, Lordship.
2 and 3.
Yes.
My lord,
Yes, sir.
Just give me a minute for about, so item number 2 is concerned, my lord. I am appearing on behalf of respondent number 14, my lord. I have filed a miss case, my lord, regarding allowing me to do my businesses, my lord. Now, so far the item number
Anyway,
2,
now we are not inclined to pass any orders. We'll take the chance for next time.
my lord, kindly look at the matter, my lord. You'll kindly see the order of the learned magistrate, my lord. My lord will kindly see my lord, kindly take up my miss case, my lord.
If I may just submit, Lordship, there was a standing order by this Honorable Court restraining them from indulging in coal activities. Now, they went with an application for Zimma before the concerned magistrate, and the magistrate has rejected it in view of the order passed by this Honorable Court. So, they have filed a misapplication against that.
Anyway, we'll see.
No, my lord,
Yes.
my lord will kindly.
So now we are not inclined. Sorry, sir, we are not inclined to pass.
I'm not kindly see, my lord. I'm not saying that pass any orders, my lord. Your lordship will kindly, give me a 1 minute to hear me, my lord. Number one, your lordship may kindly see that why my custody petition has been rejected because of the pendency of this case, my lord. Now,
That is what your friend says. What is that you want us to do? Now,
only my prayer is this, my lord, learned magistrate will consider my case on merit, my lord. Because of the pendency, your lordship may kindly take the miss case and page 23, my lord. Kindly take my miss case and page 23, my lord. Your lordship will kindly see. Page 23, my lord. Kindly want to see. My lord, it is my case. I have to prove my case, whether this coal is belong to me or not, my lord. Page 23 of my petition is this. Therefore, it is seen that the matter regarding pending of the dealing of a coal by MS Zoema Coal Limited is still subject before the Honorable High Court. And the court doesn't have
now when was it rejected, sir? When was it rejected?
It was rejected, my lord.
March, Lordship.
On my lord, on 23
20th March.
my lord.
20th March.
And that is why I
Sir,
have
20th March. 20th March. Now nearly 4 months have gone by. You can wait for another 2 more weeks.
No, we filed immediately, my lord. They took time, my lord, for
That is right, sir. Now, Mr.
Whether
Counsel,
it
you must also understand my predicament. Now, I will not be in a position to read and pass orders. Already, I am in the midst of dictation and completed 4 judgments.
No,
In fact, I did not sleep at all. Finish it. That was.
How
Yes.
I can be restrained of my lord, because only thing I
Yes,
feel that,
please. Yes.
Obliged.
my lord, this is not fair, my lord.
Yeah, 2 weeks. To take a chance after 2 weeks. Yes.
My lord.
From the daily list, item number 1.
May it please your Lordship. Lordship, I'm seeking the indulgence of this honorable court, my lord. The conducting senior counsel is indisposed, my lord. So at this matter, Lordship.
Yes, at the request of the council, post the matter on so and so date. Yes.
Lordship. Hello, Lordship.
Item number 2. Number 2.
Number 2.
Same issue, my lord.
Same issue, your lordship, number 2 also.
Yes.
Outline.
Item number 3.
3 is for release agreement.
May it please your Lordship. Lordship, here the respondent district council was supposed to supply us with the details, my lord, to take steps for other respondents, my lord.
So we have compiled it, we'll supply it in the course of the day, lordship.
So at the request of so and so to file the objections.
No, actually, what happened is they challenged the regulation.
That is right. You have to file your objections.
Objections, lordship, in the pendency of the matter, tenders have been already issued to some 100 tenderers. So we were supposed to file the list of those tenders so that they can implement those.
Then you file it.
Yes, we'll give it
Additional also responded.
additional
Post the matter
subsequent
on so and
development.
so date.
Lord. Hello, Lordship.
Obliged.
In the next page, there are 2 persons.
From supplementary list, item number 1, pronouncement of judgment.
This is the judgment. In view of the above, the judgment dated 30/3/2023 passed by the sessions judge in 50 of 2021 is set aside. The appellant is acquitted of the charge. The appellant is set at liberty in this case. In case his detention is not required in any other case, the bail bond executed, if any, shall stand cancelled, and fine amount, if any, shall be refunded to the appellant.
Item number 2, pronouncement of judgment.
See, taking note of the statement of the victim girl in the cross-examination, that at the time of the incident I was in relationship with the accused person, the criminal appeal is allowed in part, and the judgment order dated so and so, passed by a single judge in respect of 376 alone is modified to the extent that the appellant shall go on rigorous imprisonment for 7 years, because they were prior to the amendment.
Lordship.
7 years with a fine of 2 lakhs in default so and so.
Lordship. All right.
Item number 3, pronouncement of judgment.
Box saja lah.
See, during the course of the argument, it has been stated that there was no second marriage, but there was only live-in relationship. The submission made by the appellant cannot be accepted, and you have been imposed with the punishment of compulsory, discharge from service with pensionary benefits. So we are not interfering with the same. If your submission is allowed, then we will go back prior to 1955 Act. A man can marry any number of times. A living relationship is give that liberty.
Item number 4,
One more. This is
Lordship.
which one? This is a pension.
Lordship, yes. All are new.
I couldn't do anything. Post before the division bench, consisting of Justice Ding Dong and Justice Bhattacharjee, after 2 weeks.
All are your Lordship.
You also write that since the matter has been heard partly by the bench and that my brother was a party, that so-and-so Jingdong was a party to it, so it is necessary that he should be a party to the bench, appeal, to hear the appeal. Yes.
Item number 5. Number 7.
Meet please, Your Lordship. This is the airport matter, my lord.
Yes.
Lordship, I humbly pray if you may kindly take up this matter at the end of the board. Learned
Take up the
DSJ,
matter?
At the end of the board, she is asking, my lord.
Learned DSJ, he has to make some submissions. Learned DSJ has to make some submissions.
Dr.
Lordship.
Mujika,
Let him, with regard to LIDAR survey report,
Yes.
that we are going to give time. Saying that this is a matter on so and so. So in this add it for filing a LIDAR survey report. In addition to the above para submitted so and so, this actually seek LIDAR based on so and so. It's called the matter. Yes, there we will give you time. A close scrutiny of the report clearly unravels that when the Bhutan government is able to operate international flights, which are bigger in size, the most challenging airport situated at Paro, permitting mid-sized airport to land and take off at Airport Shillong is much easier for the reason that stated above in the report. The optical surface limitation in the Paro airport is less than 500 meters towards northeast direction, whereas such limitation in Shillong airport is more than 5 kilometers, which according to the pilots and other officials is not much challenging one. We have also observed the previous order data so based on the report of the amicus curiae, cluster 1 is situated 5 kilometers away in the direction following runway 22, which can no longer be cited as a reason for non-expansion of the airport, especially after a visit to Para airport, in which bigger aircraft are operational with optical service limitation of less than 500 meters, which is 10 times lesser than Shillong airport. For better appreciation, we have extracted an earlier order. Then we also suggested, we also stated that the Paro airport is situated 7,000 feet above the sea level, and there will not be much difficulty in operating mid-sized aircraft in Shillong airport, having built up of 3,000 square feet, sorry, not square feet, 3,000 feet above the sea level. At this juncture, so and so sought for time to file the LIDAR survey that has been granted. We hope that the appropriate government may take endeavor to operate hopping flights to Shillong from major cities like Cochin, Chennai, Delhi and Bangalore at least twice a week via Bhopal. This suggestion extended by for the growth and development of tourism industry and also for providing employment opportunities for downtrodden in Meghalaya so as to achieve the goal of our mission and vision 2047 for the development of our nation as a whole.
Grateful. Grateful.
Item number 8.
We also specifically stated that the matter in future the matter is going to be heard.
Yes,
My
Milord.
brother will be a party to the bench because he has already
Yes, Milord.
visited the places.
Yes, Milord.
May it please your Lordship. Lordship, in this matter, as per the order of the Supreme Court dated 29 April 2024, Lordship, the registrar was directed to send all the case records of the writ appeal along with contempt petition, Lordship, to the High Court of Manipur, Lordship.
See, already contempt has been closed. Dispose of contempt has been transferred to this court. So we wanted to know. So already contempt was heard by the Supreme Court.
Lordship.
And the contempt is closed. Closed matter has been transferred here.
Lordship, this matter was pending before this honorable court, Lordship.
That is right.
Writ appeal
That is
and
right.
contempt.
One matter correct. There are two matters. Is it not? Two matters have come before us. Can you take a chance? Who's the matter? After 1 week.
Obliged, Lordship.
Against whose order the writ appeal has been preferred? Order of? Because the writ appeal. Oh, this is from that High Court, no?
From High Court of
From-
Manipur.
Yes, yes. Manipur.
Yes, Lordship.
Yes. So it's not a problem. Yes.
Item number 10.
My lord, this pertains to the river, my lord, to the river, my lord. I have filed my detailed report in this.
I have received, Milord, the status report, Milord. We have issued certain directions, Milord. Lordship, kindly give me 1 week time to place it on record.
The status report has been filed by Mr. Yobin at the request of an Advocate General, post the matter after 2 weeks.
My lord, actually there are certain very urgent directions that needs to come, my lord. Because the entire water bodies, the paddy fields, they have been flooded with debris.
We have already taken steps to prevent. We have already-
My lord, after 2 weeks, my lord.
Yes, 2 weeks.
All right.
Item 11.
Last year.
This is a plastic matter, my lord, where there's a file in my personal capacity as well.
Yes, yes. We are passing an interim order. Use of plastics and its eradication has become a big challenge for the government nowadays. On one hand, plastics have become inseparable part of our life. On the other hand, there is awareness among the public in respect of single-use plastics and its health hazards. Then we have stated in our interim order so the extract of the judgment referred to
My lord.
by you. One of us, CJ, while hearing similar issue before in the division bench, Madras High Court has passed several interim orders with a view to do away with plastic. The effect of using plastic items and its menace should be taught to children. Our grandfathers saw water in river, fathers in well. The present generation is seeing it in tap, and the children in bottle. And let us not reduce it to the size of a capsule for the use for future generation. The plastic waste block water bodies, as a result of which the earth is not in a position to absorb water. Resultantly, and obviously, there is huge water scarcity everywhere. For example, if we keep water in a plastic bottle and pot simultaneously, the water kept in the pot will slowly disappear on account of absorption by earth, whereas the water filled in the plastic bottle will remain forever. Then we have extracted the judgment of the Madhya Pradesh High Court. And we have also extracted one cartoon. So one person was asking for a fish, and it was given by the shopkeeper. Take, this is your order, and he wants to carry it. So, where is my bag? The shopkeeper says it's already there in the stomach of the fish, the plastic bag. So that, the beautiful message is there, which you've extracted. Then reportedly every year plastic kills 1 million seabirds, sea mammals, turtles, etc. on account of plastic pollution. Wildlife simply disappears as the most of visible impacts of plastic debris or the ingestion, suffocation of species. In yet another, so if a citizen of India visits Singapore, he would throw plastics and waste items only in the dustbin, fearing imposition of heavy penalty, whereas such items would be thrown to the floor once the very same person lands in India. Mere dream of conversion of a country as that of a Singapore alone will not be helpful, and strict prohibitory measures and the imposition of heavy fine on the violators are the only solution to eradicate plastic from society, in addition to spreading awareness about the menace of plastics. The government must be vigilant that plastic items are shopped at the entry level itself. All the plastics, whatever it's the one, it should be stopped. Next to the High Court, wraps. No, we have not mentioned about wraps. Next to the High Court, we are able to witness that there are accumulation of plastic in shops. A periodical raid should be conducted in all shops, and the government of Meghalaya should think of imposing huge amount of fine against those who use plastic within the state of Meghalaya. Strict enforcement of law alone will be helpful to get rid of these plastics. To begin with, such a move can be started from temple premises. Temple authorities must ensure that there is no usage of plastic bags in and around the worshipping places. Periodical inspection should be conducted nearby shops, and if any shops are found to have stored plastic bags, heavy fine should be imposed on them. And if the practice is continued, such shops should be kept under lock and seal. CCTV cameras should be installed in all temples, so that if anybody carries plastic inside the temple, that can be curtailed to some extent. So these are all things which you have passed. Post the matter, so and so, after 3 weeks.
My lord.
We will take steps and report on the next thing.
Yes.
And in the meantime, my lord,
Later, government is expected to file a counter affidavit by reply as to the steps taken by them in curtailing the use of plastic within the precincts of Meghalaya.
my lord, in the meantime, I may also seek for my lord's liberty. I may also submit more affidavits in respect of
Yes,
this, my
it's
lord.
a PAL, you can do that. It's not a problem at all. So ultimately, state as well as the individuals will have to
Yes, ma'am.
coordinate and ensure that, see, we cannot blame the state or
Yes.
who is using,
Yes.
The public.
individuals are using.
There's a group of there's a group of friend of mine, my lord. They have told me that they try to do this one by their own in Juwai city, my lord, where they when they go to buy meat also, they take the tiffin, my lord.
That's right,
And in
that's
that way, my lord, but once they stopped that campaigning, then we went back to
Here
the
we are making vegetables,
my lord,
we are making curry from vegetables.
my lord.
Ask them to make curry in plastics
Plastic.
and give them on, ask them to eat
My lord.
and let them decide whether it is digestible or not. So at least the doctors will have a roaring practice.
Obliged.
One advocate from Madras has come here. His relatives, all his relatives are advocates.
Obliged.
Sorry, not advocates, doctors.
Doctors. Obliged.
Item number 12,
13 IFPF for the petitioners. Is that matter wherein the personal hearing notices, the last two personal hearing notices were sent on the same day, which is in violation of the master circular issued by the Ministry of Finance, Central Board of Indirect Taxes and Customs.
My lord, I was required to take instruction. My lord, the matter is from Manipur, my lord. So I have not been able to receive instruction. If the matter comes up next week, my lord.
No,
week or 10
my
days
lord, my lord, the order was issued by the additional commissioner in Shillong. So this court only has jurisdiction. The order.
And I'm not talking about jurisdiction, my lord. I'm only saying that the instruction has to come from Manipur, where the notices were issued.
What's the matter?
My lord, this
Yes.
my lord, if I may submit one aspect, my lord.
So you take it on next week, sir. Posted 1 week.
From the daily list, item number 1.
May it please your lordship. Your lordship, this is a legal aid matter, your lordship, where we have filed an appeal asserting the judgment order passed by the London Trial Court, whereby the appellant has been condemned. Your lordship, this box matter, your lordship. And it's a legal aid matter, your lordship.
What is the age of the victim?
She's 10 years old, your lordship.
10-year-old.
Yes, your lordship.
Convict.
For 25 years, your lordship.
Convict. 25 years. Punishment?
May it please your lordship. Lordship, that is a transport there. We have filed the affidavit, your lordship.
Lord,
Speed detection,
Lordship, yes.
state is yet to install those cameras, my lord.
yet to install.
Yes.
Lordship, we filed the affidavit. If lordship kindly come to para 4 of the
Take a
affidavit.
chance. After 2 weeks,
Lordship,
post the matter, the request of respond, post the matter after 2 weeks.
Obliged.
2 weeks,
Lordship, Lordship, there was an order that the officer of the police department and the transport, their
say, let it come after 2 weeks, then after you take time.
kindly, their appearance may kindly be dispensed with your lordship.
They have to appear.
Lordship, they are on there.
We asked them to appear.
Lordship, there was an
When is the order? That you have not pointed out.
Lordship, kindly come.
The official will respond to the request to be present in this court through video conferencing on 16/8. Where are they?
Lordship, they are here.
Yes. So what is your submission now?
Lordship, we have done, your lordship. If lordship kindly come to para 4, your lordship, there are 349 CCTVs.
So and so has appeared online. The presence is dispensed with.
Lordship.
But anyway, we have not asked them to appear in person. They can also watch what is happening in the court. It's a very sensitive PAL.
Lordship, I'm sorry.
So let them come. They are free. They can appear.
Lordship, yes. On the
Only 2 officials are there.
Lordship, yes.
So at least one can appear through online. So they can watch what is the program, what is the views of the court and the mind of the court. They will understand.
Lordship.
See, in those days, people will be asked to come here. They will have to set apart the work, wait for the whole day. Nothing will move. Case will not reach, and they will go back. So we are not asking them to waste the time. By click of the button, they can come online.
Lordship, they are online.
That's right.
Lordship, yes.
Let them appear in the next hearing also.
Lordship, yes.
Well, we are not asking. See, those is being,
Lordship, on the date fixed, we will inform them accordingly, your lordship.
yes.
So as
So now the presence of the officials
Lordship.
are dispensed with, as and when required. This court will require the presence.
lordship.
So and so and so.
Obliged.
See,
Obliged,
into litigation, if the officials appear, they will know, they will be in a position, they will have better information to give to the court. Understand?
Lordship.
See, it's not against somebody. It is ultimately we are going to do something to the society. That's very important. See, in Tamil Nadu, Mr. Radhakrishnan, IAS, he was a commissioner of corporation, and Mr. Bedi, he was also. These persons appeared online, and several matters got settled because the Advocate General and others were not in a position to give the information. When they appear online, they said we'll settle the matter, and within a few weeks, the matter got settled. That was the reason why we are asking them to appear. So we are not going to have any pressure seeing them, and they will have the pressure. Yes, because the court has asked them to appear. Yes,
Obliged, your lordship.
yes.
Item number 4.
You note down the names of 2 officials that they have appeared, and the presence is dispensed with. Yes.
May please, your lordship.
Case where the last occasion regarding the regularization of our lordship has
So with regard to 18 days wages,
My lord, it has been extended to 2 months, my lord. My lord's
2 months.
Yes, my lord. Or my lord's order of 15/7/2024.
yes, yes, yes.
my lord's
My lord,
Can
may I
you take
just,
a chance before next judge?
my lord, I agree with my lord's order of 2 months, my lord. That may be, my lord, because my lord, just observations, my lord, there, my lord, just.
Let it be there.
My lord.
You may get better order.
My lord's follows from my lord.
You may get a better order from the other chief justice. Yes.
Item number 5.
This is the limestone, my lord, matter which has been settled by 9 judges bench, my lord.
The judgment has just been delivered by the Honorable Supreme Court last week.
And power of the state to impose tax and sales.
I think issue is covered.
Look, we're just examining it. I was praying your lordships kindly have it next week. 140-page judgment holds.
Request of
342 conclusion is in paragraph 342.
Anyway, because I will also have to read and then only pass out. Yes.
From supplementary list, item number 1, pronouncement of judgment.
You don't respond with the times. The entire section of section 7 has got to be read as a whole, not in isolation. And upon going by an harmonious reading, gratuity has got to be necessarily paid in accordance with the provisions of the Gratuity Act. And you refer to the judgment of the Madras High Court, my lord. It was passed by me, there. I said, the judgment of the Madras High Court is not applicable to the facts of the case in the light of the judgment of the Supreme Court in 2014, where this court has considered the question of laches in that case, not on merits. No doubt that the delay in filing an application claiming gratuity, interest can be deprived in terms of section 7. Once the controlling authority passed an order, the employees are entitled to gratuity along with interest. In this case, controlling authority has reviewed the order filed by the employer, which according to employees is not sustained. Then we quoted Rule 18.5 of the Central Rules. The Apex Court in a judgment reported in 1999 4 SEC 450 has held that the facts are not in dispute, relegating to an alternate remedy is not required. The payment of gratuity to the employees is a duty cast upon the employer provided under the Act, if the same is applicable. In this case, the Act is applicable to the employees, which is not by the employer, not disputed by the employer too. Statutory interest is payable automatically in absence of payment of gratuity by the employer to the employees within the stipulated time. Gratuity is not a gratis or bounty, and it has got to be paid to the employees for the services rendered by them in case they complete 5 years of continuous service in terms of the Payment of Gratuity Act. When the employees have been deprived gratuity in the year 2004, and after they were made to leave the respondent under the Golden Handshake scheme, and the retirement benefits were paid only after 15 years in the year 2015. One more page. Then we also have observed that if the contention of the employer is accepted, and the matter may be remanded back to the controlling authority and the appellate authority to decide the issue of payment of interest, it will not serve any purpose for the reason that it would amount to multiplicity of proceedings by one before the controlling authority and thereafter appellate authority, High Court, and thereafter to the Supreme Court. Ultimately, the employer, after conclusion of the proceedings before all the forums, will be forced to deposit the interest amount only in the coffins of the employees and not in the account of the employees, which is not the intent of the welfare legislation. So we said
that instead of paying 10% interest, because there is a delay also on the part of the employees. So we said that instead of paying interest at 10% per annum, pay 6% per annum within a period of 4 months. We also refer to the judgment of the Supreme Court in 1993 3 SEC 214 and held that if the amount is not paid within 4 months, the amount of interest has got to be recovered from the officers concerned. So now we have got 4 months time to go to the Supreme Court. 3 months, 90 days. Yes.
Yes.
Item number 2.
This is an appeal directed against the order dated 25/7/2024. Very limited issue involved, my lords.
What is this matter, sir?
Well, what has happened here is there are 7 writ petitions, my lords, which are pending before the learned single judge. Now, these are with regard to different villages, my lords, that different writ petitions are pending. Now, on the relevant day, my lords, if I may just take your lordships to the impugned order, 25/7/2024, your lordships would find that at...
What is a miscellaneous petition?
My lords, that's for grant of leave, because an order has been passed in a writ petition where I am not a party.
This is petition which was filed by yes, then if he is admin, he may fall. So whether we will have a separate trial or not, because it seems like there are some villages under this. And these villages are not.
Take a chance on Monday. Yes. Speak.
I think this will the leave this court. This will be the last time we will be seeing your lordship in the courtroom. What?
From the daily list.
No, the list is left.
I won't be seeing anymore. I thought in this matter. So lordship, this indulge you after the last matter. Small leave, lordship. Just want to make some statement after the last matter.
Which matter?
No, not in a matter, my lords.
Not in a matter. Not in a matter.
My lord,
Lordship will be any other matter.
daily list.
After the daily list, lordship.
From the daily list, item number 1.
Take it out. Post next week. Post after 2 weeks. Yes, Mr. Khan.
Sorry. Very pleasure, Lordship. In fact, I'd like to express our gratitude that we miss your Lordship also. In fact, we pray that Lordship will visit us time and again, although I could not appear in many of the cases due to some ill health. In fact, some decisions has come forward from your Lordships. So we lawyers, we are really glad. That is quite good number of disposal we had.
Yes.
And in fact, from the bar also, and plus individually, I express my gratitude to your Lordship.
Thank you very much.
Thank you.
Yes.
And lordship, though a formal full court sitting will be held at 12:30. But then at this moment, your lordship, I'm filled with a mixed emotion that perhaps we'll be seeing your lordship for the last time in the courtroom. And there are rare occasions in the life of a lawyer when, in the same day when I'm wishing your lordship a happy birthday, at the same time, in the same breath, we'll have to wish you a farewell, your lordship. Lordship, it's been an honor and privilege the last 6 months. The amount of disposal, the amount of quality cases.
Stay here and bar very, very, very nice.
It was a very enriching experience, your lordship. Short stint, but fresh breath of air. As lawyers, your lordship, we have to see the landscape of different trajectories. We have different experiences of landscape, but this short stint has enriched the bar, especially the young juniors. And we feel honored and privileged, your lordship, and we can wish you all the best.
Juniors will have to be encouraged. That's what I feel. And my brother judge from Madras has also come. He's also like me, used to encourage juniors. But as a lawyer, I know he was very strict towards the juniors.
Lordship, we can wish Lordship all the success. I hope this is not the end of Lordship's career, beginning of a new illustrious career, maybe things that you do, but you feel better. And Lordship, we can wish you all the best with good health and with the same sense of humor and joke.
Yes.
All the best, Lordship. It was an honor and privilege to have appeared before you, Lordship.
I can only echo what my learned friends have said before me. Just wish you luck.